Hi, Bill Henshaw here again for the Constitutional Crisis channel. Today's video, and it may be a bit longer than the ones that you've seen up to date with few exceptions, is what I'm going to call Traffic Arraignment 101. As I just had one with a friend of mine yesterday in the traffic court, and this probably happens in every one of these traffic quote-unquote courts across the country, how this goes. But the important points here, if you recognize and understand these things, I can help you with document packages I have ready to go here, and we can beat them across the board in at least traffic court, if not quote-unquote criminal court as well. Now, this was a typical arraignment day. We went in there and we had at least 70 people on the arraignment calendar, and there may have been more than that. And my friend was number 30, so we didn't know we got there at 8:30. It started reasonably promptly, which is unusual because the bastards normally make you wait a good 15 or 20 minutes to intimidate you even more. This one started relatively early, and as is often the case, and probably true in your state, quote-unquote, too, these arraignments, this commissar here was knocking them off about one every 75 seconds without any comprehension of what he was doing. And unfortunately, I didn't see a single person at this particular arraignment that had any clue what to do at what is arguably the most critical point in the entire process of the quote-unquote criminal justice system, at least according to the Supreme Court of the United States. And that's what needs to be changed. If we beat them here and we beat them early, that gets us out from under without having to waste any time, effort, money, or anything more than we have to do. We get them there at day one. And not only that, if you do that and you do it more than once, you would think the DA is going to be smart enough to have people trained in the traffic division that when cases come along with your name on it and you have this kind of a record, they won't even bother to file charges anymore because they know it isn't going to be worth their while to do it. That's one of the big wins we can get here. Or if they file charges, we're eventually going to get enough of these cases into the quote-unquote state Supreme Courts that they're going to have to decide the issues that we raise, and there's only one way to decide them, and that's going to put these bastards out of business, which is exactly where they need to be. Getting back to the arraignment, it was a bit odd. I didn't really have any idea what to expect. I thought they might dismiss it early on, which has happened a couple of other times in the same quote-unquote court. We've gone in there, and my friend has been called up relatively early, and they just dismissed the charges there and then because they knew what was coming. They damn well knew what was coming here because I had very carefully set the record with documents you can get a hold of at a very reasonable price at my at ccaspari.live.com, ccaspari at live.com. I have document packets available there. Check it out and ask me for them, and you set it up in advance. And what we did here was right away we filed a demand for a bill of particulars. About a week after we got news of the citation, which was one of those infamous red light tickets. So we did that, and the demanded bill of particulars is so that, the government has to tell you what the nature and cause of the accusation is. In this day and age, it's not well understood what that means, but people in 19th century America, and especially those who framed the Constitution, understood that the government had to identify the jurisdiction it was using against you. And the whole idea of the revolution here was that most of the process that went on between the government and the citizens with the capital C that ordained and established all government was to be pursuant to the common law. Well, that's not the jurisdiction in which these traffic cases occur. While it may not be 100% clear as to what it is, it damn sure isn't common law. And they've got problems because if the two choices I see, if it's Admiralty Maritime, as I've said in other videos, a state court can't exercise that jurisdiction. That's the jurisdiction foreign to our Constitution and unacknowledged by our laws that set off the entire American Revolution. And they're prohibited by Article 3 of the Constitution and by Section 9 of the Judiciary Act of 1789 from using that. So if that's a jurisdiction that we're in, and you notice when you go into their courtrooms, quote-unquote, what do you see there? State flag and the United States flag with a yellow fringe around it. That's a military border. That's a military standard is what it is. And that's prescribed pursuant to Army regulations by the President of the United States, acting as Commander-in-Chief of the Armed Forces. They're telling you where they are, but they never overtly on the record tell you. And that's what, you can make the argument, that's what they're using as admiralty. And if that's the case, no jurisdiction, we should be able to move for an immediate dismissal on that ground. Only other possibility is even worse, federal regional martial law rule. And if it's that they're using, then they're going to need to come up with a known declared state of rebellion or invasion. That's the only way they could possibly exercise that. And they don't have one. And the big case, and I mentioned this on several of my earlier videos, is Ex Parte Milligan, Milligan, 71 U.S. 2. So we have a big jurisdictional problem there. So knowing that going in, I mean, you know that they don't have jurisdiction, and that's, in the bill of particulars, that's why we demand the nature and cause. Tell us where you are, because if we don't know the jurisdiction you're using, we can't possibly know what applicable rules and regulations exist there, and therefore we can't put on a defense. Simple as that. And that's why they have to tell you, and they don't do it. And by the way, I note here quickly that in the 19th century, or up until that time, in federal court, typically the first page of the complaint, whatever it was, civil, criminal, whatever, it would say the jurisdiction. Now, in admiralty cases at the time, the petitions there were called libel, L-I-B-E-L. That was the name of the action, and that would identify it as admiralty. But you could have equitable cases there, you could have common law, and there could be some other jurisdictions that might come into play. But the key here, especially with admiralty cases, was if you knew that in advance, then you would be on notice that you had a right to invoke your right to the Savings to Suitors Clause under Section 12, I believe it is, of the Judiciary Act of 1789, to save your common law remedies, namely the right to trial by jury, which you don't have in an admiralty setting. So if they disclose what they're doing, you could fire right back and demand your right to trial by jury, which they can't give you in that jurisdiction. That's going to defeat them. The BOP also covers the fact they have to disclose all the elements of the quote-unquote crimes you're being charged with. In a traffic case, that will typically include the fact that you're a quote-unquote person required to have a driver's license. Now, I'm not going to recover it here, but in earlier videos, we've discussed the meanings of these terms, persons and license, and you can look into these videos and see, and I'll put them in the notes below as to which videos these are. You can go look what I've set forth. They can't prove any of it. If they can't prove it, they can't get a conviction. And I think that's a structural jurisdictional error, and it should be. This is not a harmless error we're talking about here. And they know it as well as I do. And if they proceed against you under those circumstances, then they're acting in legal parlance coram non judice, which is Latin for you're not acting as a judge. In effect, you're acting as a private individual, and now your ass is on the line. You don't have any quote-unquote judicial immunity to invoke against me. If you're acting without jurisdiction, that's on you. This is what a BOP is designed to do, a bill of particulars, and you demand it each and every time at your first opportunity. We did so, and we sent a copy to the clerk of the court, quote-unquote, not to be filed there, but to be received. So it was in the court record. Not surprisingly, the DA didn't even acknowledge it, let alone respond to it. So they've agreed with us that they don't have jurisdiction. If they're not going to provide it, they're the ones that have to prove it, and they didn't. We followed up, maybe more importantly, with a notice of denial of assistance of counsel. And that one is the sacrosanct right. I mean, it's going to beat them every time, because we're saying, we would love to have your assistance of counsel here, but the Constitution tells us we can't have it. For jurisdictional reasons, we want to come in here and challenge the jurisdiction of the court, and we can't do that with an attorney. We have to be a belligerent claimant in person. The Supreme Court has said that in so many words. I have case law that says it, and even in Black's third and fourth law dictionaries, you look that up, and you'll find under jurisdiction that you can't challenge it, with an attorney. He's an officer of the court. His appearance gives the court, quote-unquote, jurisdiction. It can't get in any other way. But at one and the same time, the Supreme Court has said, and I quote here almost verbatim, that let the trial judge know at the beginning of each misdemeanor trial that the accused cannot be sentenced to jail, though local law permits it, if he was not represented by counsel at his trial. Okay, the case is Argersinger, Argersinger, v. Hamlin, Hamlin, 407 U.S. 25, page 40. Now, I've discussed this one in earlier videos too, but I'm making the point here. That's how important this is. No counsel, no jail. And your position is you might love to have their counsel, but you can't because you have jurisdictional issues you have every right to make, and they can't deny it. This is what you call between a rock and a hard place. So this notice is already in there. We sent it to the DA, and again, they ignored this one, and they certainly made no attempt to refute it, which means they've agreed to it. I mean, that's the same rules they use with us. If you don't reply in within 72 hours under the Uniform Commercial Code, you bought it. Why doesn't it work the other way? And these are the documents that when my friend's case was finally called, and she made an offer, because we had copies of the documents, because we didn't get any correspondence back from the clerk of court that these had been filed, and they didn't send back conformed copies, which was unusual. This girl in this situation is really good about it. And I told my friend, she might have been ordered, although we don't know by whom, not to file documents, perhaps especially in your case, because we're going to set a record like this. And now it's going to get reviewed. So we didn't know. I sent a follow-up letter on this 2 weeks before the quote-unquote arraignment. That wasn't responded to. I went to the traffic quote-unquote court the week before, bringing these documents with me and saying, I need to have these put in the record because we haven't received any response to it at all. And I had all the proofs there, all the receipts for mailing, everything. And I did get a conformed filed copy of the notice of denial of counsel. Now, at the time, they couldn't find the record anywhere at all in the clerk's office, which struck me as very strange. I don't know where it was, whether it was in the commissar's headquarters in back of the court, whether it was with county counsel, the DA. I mean, I don't know to this day where it was. But I got it in there, and that's what I gave my friend, a copy of that conformed copy to present to the traffic commissar, and she did so. Now, she didn't have enough training, and she will have the next time she goes in there, to be able to tell the commissar exactly what was going on there. But in pure point of fact, what's going on is you would think this guy would have read this record. You would think somebody would have pointed out to him or had the job to say, hey, take a look at this. You might want to take a look at this case and dismiss it. Because if you go in there against her and she's not represented by counsel, you're committing acts of treason. And I believe we can prove that in a common law court in front of a common law jury. That's how important this stuff is and how critically important it is at the quote-unquote arraignment. The good news, though, about that is they can't hold us to it because, they're very fond of saying, well, ignorance of the law is no excuse. To which I reply these days, the hell it isn't. Since when did you teach us what the law was in your mandatory public quote-unquote education system? It ain't there. It wasn't there when I was in school 50 years ago. It wasn't there nearly as much when my mom was in school 30 years prior to that. How are we supposed to know that? You keep obfuscating things. Your courts won't rule on the issues. We have no way to know what the law is. And nowadays in California, and probably in your quote-unquote state too, you can look it up. In our counties, we have an office called county counsel that's unelected, unsworn, unbonded, with apparently a perpetual term of office, and all of whose communications by their own admissions to elected quote-unquote officials is confidential pursuant to attorney-client privilege. In other words, what they're saying is that we're the ones that have the right to know what the law is. All we expect you to do is obey it. Parenthetically, whether or not it's in pursuant of the Constitution or not. They don't care about that at all. By the time I get through, they're damn well going to care about it. Then you can come to the same conclusion and do the same things yourself. That's what I'm going to show you how to do. And that's what my document package I now think is going to do. They can't get around this any way, shape, or form the way I have set it up, because we're using their own statutes against them, something I would have thought 2 years ago would be impossible. I now know that it isn't, and not only that, but the issues we raise, they can't avoid, because they're the ones invoking the jurisdiction of the non-existent 14th War Amendment, and we're challenging it on their terms, and at the right time at the traffic arraignment. As I said, fortunately, for those of you who are past that point in time, we can take care of that too, because they only got you through the arraignment under threat, duress, coercion, fraud, and even treason. So any plea that you might have entered there will not be voluntary, knowing, and intelligent. And that's the reference standard that the Supreme Court says it uses to test for the validity of such a waiver. And that the case there is, I'll think about it in a minute, but they used that, and this comes out of an earlier case called Crain, C-R-A-I-N versus United States, 162 U.S. 625, where they said that the arraignment has to have these particulars or it isn't valid. And by the way, the case with involuntary knowing and intelligent is Johnson v. Zerbst, Z-E-R-B-S-T, 304 U.S. 458. Now, I note for those of you in California looking at this video, in the Crain case, the court cited with approval an extensive excerpt from a case called People v. Corbett, C-O-R-B-E-T-T, 28 California Reports 328. And if you read that, the Crain case and the Corbett case, and you see what an arraignment is supposed to look like, and you then walk into any one of our traffic quote-unquote courts these days, you are not going to see anything remotely resembling it. Since when did we waive all of these rights? That's the question I want them to answer. And they can't make any claim that that was done during the quote-unquote ratification process of the 14th War Amendment. Not there, because people didn't know at the time that the amendment was going to be construed in that way later by courts. And if they didn't know that the Committee of 15 had a lot of secret motivations in this 14th Amendment that they didn't bother to tell anybody about, that's fraud. And it probably is treason too. And it vitiates everything they do, what's called legally ab initio, from day one. That amendment doesn't exist, and any purported waiver of rights does not exist. And this is true, whatever court you're in, whether it's traffic court, criminal court, bankruptcy, quote-unquote court, doesn't matter what the hell it is. So we've gotten all there with a government gun to our head, and this is the way to disengage ourselves and get out from under. This is what my documentation will do from you. And you sit through these traffic court arraignments yourself. I encourage you to go once in a while and just sit through one and see if it isn't exactly what I'm telling you that it is here. It's a meaningless ritual. That's all they do, and all they want to do is make as much money as they possibly can, as quick as they possibly can. And I would say out of the 70 that we went through, probably 50 or 60 of them opted to pay, quote-unquote, the fine on the same day. I mean, my goodness. And then the commissar says, and this arraignment occurred on November 17th, that for those of you who pay your fine by January 4th of next year, you don't get a point on your record. Wait a minute. Isn't the concept behind these vehicle code statutes the protection of the public safety? What in the world does how long it takes you to pay a fine have anything to do with that? Either you did something wrong or you didn't. That struck me as awfully strange. And right in the next breath, the commissar says, well, if you want to take traffic school, that costs an extra $100, but you won't get a point on your record if you do that. Well, my goodness, I thought to myself, I've never heard this kind of thing somewhere before, and I said, I sure have. That's Monty Hall. What the hell they're doing there? I mean, that's all this is. There's no public safety anywhere in concern in this whole process. It voids the whole thing, even if they could have lawfully enacted it. If they're going to engage in these kinds of shyster shenanigans, I mean, what the hell is it telling you about a traffic arraignment? And then you get to the quote-unquote trial. We're going to have a video on that one when this trial occurs, or I may do one before pending, but there may not be a trial here because we're going to hit them with so much paperwork, all of which you can get at a very reasonable price, by the way. I'm going to hit them with subpoenas, and they're going to have to show up with documents in hand proving that they're lawfully entitled to their offices and that they're acting within the scope of their duties, and there isn't any way in hell they can do it. I mean, we've already had 2 cases dismissed on this. This is going to be number 3. Actually, number 4 within the last 9 months, which is amazing. And if we go to the California Supreme Court, we're going to get the 5th case dismissed that should have been a long time ago. And I've got a friend of mine probably going to join me for case 6. We're going to get all of those dismissed. And we may well get an order from the California Supreme Court enjoining the enforcement of a lot of vehicle code statutes for the same reason, because I don't care what statute it is. Whether it's the insurance statute, whether it's the license statute, registration, the same arguments come into play. And we can beat them across the board. And that's why I'm in business here trying to do what I do. Once we do that, and we get one case like that, that's good coast to coast. Especially if it comes out of the Supreme Court of the United States. That's where I'd really like to get it done. But if we get it done in a state like California, other states are going to take notice of that. Trust me. We have a lot of clout here, one way or the other. So that's what we're trying to do. As I say, I have packets of documents here. You can contact me. at my email at ccaspari@live.com. That's CCASPARI at LIVE.com. And, tell me your thoughts and comments about this. And if you want to purchase any of the packets and materials we have, let me know, and we'll work that out too. Thank you.